Hi, I'm Florida foreclosure defense lawyer Michael Wasylik. I'm here today in Bartow, Florida, outside the historic Polk County Courthouse. And today I wanted to address an issue that's coming up recently because it's becoming popular on the internet. And that issue is the question of TILA rescission, Truth in Lending Act rescission, what it means, how you do it, and who can do it and when. Now that's a lot to cram into a video of just a few minutes, so I'm going to give you a little bit of an abbreviated version. But basically speaking, rescission simply means undoing the transaction. And that under the Truth in Lending Act, anyone who gets a home mortgage has the right to rescind that transaction within 3 days. The purpose of this, it's like a cooling off period. It gives you time to read the documents that you were signing, make sure that they were the documents you thought they were, that the terms of the loan were what they thought you were, and if they weren't, you have a chance to back out of it, to undo the transaction completely, give the money back, or don't take the money if it's still in an escrow account, and cancel your obligations, be free from the obligation entirely. Now, under federal law, everybody has that rescission right for 3 days from the time they sign the paperwork. Now, there's one exception, in that if you're at the closing, you don't receive a Truth in Lending Act disclosure that tells you about that rescission right, you may have the right to rescind the loan for up to 3 years. Now, that's an awfully long time to be able to rescind a home loan, and so there's some complicated procedures that have grown up around that. What it means when you rescind a loan after you've already taken the money, bought the house, moved into the house, and lived there for 2.5 years, whatnot. One of the issues that is required is that you have to make some kind of tender of the rescission. In other words, what that means is you have to offer to the lender some way of undoing the transaction, giving the money back, giving the house back, something like that. Now, obviously, that could be very complicated. And there's some myths that have grown up around the rescission right on the internet. And if you believe you're in a position where you think you might have the right to rescind and you might want to rescind, you need to be aware of those myths. The first of all is there's a myth that's going around that says that under certain circumstances you may have longer than 3 years. That's just false. The law is very clear, and every court that's ever weighed in on this has been crystal clear. It's 3 years, no more, no less. There's nothing you can do to extend that 3-year period. Now, the theory that's being kind of pushed around online is that there's this 20-day period where once you send a rescission notice in, that if the bank doesn't respond in some way within that 20 days, by filing a suit to challenge a rescission, whatever, that somehow your rescission is effective, even if it's beyond the 3-year time limit. That if they fail to challenge that within the 20 days by filing a lawsuit or some other method, that their failure to challenge within the 20 days waives the 3-year limit. That's complete garbage. That's unsupported by the law. And there's no court system in the state or in the country that will actually agree with that. Because here's the problem. The theory depends on the fact that it depends on courts agreeing with it, and here's why. Because the rescission, although it is self-authenticating within the 3 years, it is not, or it's self-executing rather, within the 3 years. It is not self-executing to the extent that it's automatic, or in other words, if the bank just simply doesn't cooperate because they don't believe they have to, well, what do? Well, you have to go to court, and you have to ask the court to impose on them that requirement. Now, the theory is that if they fail to respond in 20 days, the court system will actually make them honor a rescission right, even if it's far beyond the 3-year period. That's just not going to happen. The courts hate to impose that rescission right, and that's why it's so heavily litigated when it's put into place. So the idea that the 20-year period, or the 20-day time limit, somehow allows the borrower to extend that 3-year period. There's just no support in the law for that, because every time that happens, the banks are going to simply say, you're beyond your 3-year period, therefore this rescission is ineffective. And whether they've waited 20 days or a year or whatever to tell you that, once they refuse to recognize that rescission, the only way for you to try and enforce it is to go into court. And there's no court in the land. There's no court in the land that's going to say, sorry bank, you had 20 days to respond, you had 20 days to file some kind of lawsuit, 20 days to challenge that rescission, and because you didn't act in 20 days, we're going to give them, the borrowers, more than 3 years. We're going to give them 4 years, 5 years, whatever it is. There's no court in the land that's going to do that. So be careful what you read on the internet about this TILA rescission right now. If you are within your 3-year period, you didn't get the disclosures, or you're within 3 days and you want to rescind, you want to talk to somebody about what it means to have a TILA rescission right, go ahead and give us a call. If you're beyond the 3 years, it's our opinion you just can't do it. But if you're within 3 years and want to rescind, we have some ideas about how to do that. So give us a call. I'm Florida Foreclosure Defense Lawyer Michael Wasylik. You can reach me at 352-567-3173. That's 352-567-3173. So if you have a loan that's less than 3 years old, you think you want to rescind it, let me know. We'll see what we can do. Thanks for watching.